This was truly about justice. This child is going to have lifelong issues, and she should still be compensated.
Welcome back to the glamorous grind.
Today's guest is someone who turns devastation into accountability. When tragedy strikes the family, Keri Nahama is the one you want on your side. A defense attorney tells the jury, kids are resilient, they'll bounce back.
Yeah, no, red flag.
Oh yeah.
Yeah, for sure, 100%. Let them say that. They're just digging their own grave.
If you're in San Diego's legal circles, you know her name. And if you're a woman trying to do everything, you need to know her story.
Especially when it involves children. What I say is your child injured? Is your child suffering? What's your child going through? That has a value. Do you agree?
She is proof that your purpose doesn't need to compete with your personal life. It just needs you to stop asking for permission. Keri, thank you so much for joining us. This is such a privilege to have you on here. You're a badass mom, a badass attorney. Why don't you tell our listeners a little bit about yourself?
I have always wanted to be a lawyer. I don't know why. My parents aren't lawyers. We didn't run in circles where there were lawyers. It was just something that I always wanted to do. And if you looked back at my 6th grade yearbook, it would say in there that I wanted to be a corporate lawyer.
Wow.
Which had no idea what that meant. But
it was your calling innately, it seems like.
Innately. The first internship that I had was with the city attorney's office. And we had cases where the one that really I remember and stands out is this woman was getting married, right? And she paid her photographer like $5,000 up front as a deposit. And he never showed up at their wedding. And so the city attorney, it was the Consumer and Environmental Protection Unit, they took on that case because you can't do that to people. And so just from, that's not personal injury, right? But from that, I'm like, that does suck. Like, something needs to happen. I mean, it's your wedding day. That is not cool to just not show up. So
I didn't know that cities take cases like that for private individuals.
Yeah, consumer protection cases. So we also did a lot of grocery store cases where they said the meat price was one thing and then, it was like changed, a little bait and switch action.
That's interesting because my mom was telling me the other day she went to Trader Joe and the eggs were supposed to be $5.99, but they were $6.99. That's what she's been charged on receipts every time she goes. And my nephew now, all of a sudden, he wants to sue everybody and they don't know where it's coming from. So he's like, we need to sue Trader Joe. So we're laughing about that yesterday because,
maybe he wants to be a city attorney.
Yeah, funny story.
That's one of the things they do. So I did that. And then the next internship I had was with a personal injury attorney. And from then on, I was just mesmerized. I mean, the cases and the people and just everything about it I liked. And it just felt like it just fit with my personality and my skill set, really.
And doing PI from day one?
From day one.
Awesome.
Yeah.
What kind of cases have you handled?
Lots of children's cases, which is a focus of my practice now, and lots of car accidents. I did take a short kind of detour into wrongful removal, CPS cases, civil rights cases.
You got a like $2.1 million
Yes.
verdict. Was that recently?
That was a couple of years ago, but what that started out with was an accident to a little girl, an injury to a little girl at a daycare center. And so what happened in that one was mom picked her up. She had broken blood vessels on her face that her mom was just like that. She thought it was a rash. Maybe she ate a strawberry, whatever. So it didn't look right to mom. Daycare provider didn't know what happened. So mom took the child to Rady's, and immediately that type of an injury is from strangulation or something like that.
Really?
Yes.
And who was it?
Like
who did that?
Strangulation. The daycare.
Are you serious?
Yes. And because when mom dropped her off, she didn't have the injury. And when mom picked her up,
God.
she had that. And so immediately the doctors were like, this is now
gave me
escalated.
Goosebumps.
I know. This is now escalated to being a, abuse case.
The child didn't tell her mom?
That was one of the issues with small children who are nonverbal. If you have a child who's nonverbal and an injury happened that nobody can explain how it happened, then that poor child has to go through the entire gamut of all of the abuse kind of testing. They have to have, cranial exams. They have to have full body scans.
The other day, my daughter came back from daycare and she had this huge thing on her leg. We had no idea what it was. I was like, did she get bitten?
Call
No
Keri.
one knew.
Yeah.
No one knew. And then we took her to the ER and she had like a bee bite that went really bad. She had to go on antibiotics. It got infected. But something could have bit her. They wouldn't even notice.
Yeah. In this case, once that happened, then CPS got involved. And once the parents went home, CPS showed up at their door at 11 p.m. and they're like, we want to talk to you. We want to come in. They're not allowed to do that unless they have a warrant. Right? You don't have to let them into your house, but people don't know. And they're like, yeah, let's talk about the daycare. What the heck happened? I want you to go over there and talk to them. So that's why they let them in. But once they let them in, then they took their children, both of them.
They presume that the parents did it?
Yes. Because the child's nonverbal and they don't know what happened and nobody can explain it.
Wow.
They shouldn't have taken the children.
Yeah.
They can only take the children if there is some kind of an imminent harm, right? Without a warrant. They should have checked the daycare first.
And nobody investigated daycare. The police didn't go and question them.
Eventually, yeah.
But not before the children were taken away.
The child was 1.5.
Oh.
Yeah. She was a baby. So the children were at Polinsky for, I think they were only there for like 48 hours. But I did take a little detour on those types of cases because it's not right. Yes, CPS has an amazingly hard job, no question about it. And they see a lot of really horrible things, but they have to understand people's constitutional rights and parents' constitutional rights before they just remove children.
Seems like the CWS has been paying a lot of money to a lot of people recently, from a $4 billion verdict in Los Angeles County to now Polinsky Center is being sued here, and even
mistakes.
Other practitioners like yourself bringing individual cases. It would be so much cheaper for them to hire right and follow their procedures and invest that money in training their people instead of paying all these lawsuits.
You would be amazed at, because I sat through so many social workers' depositions on these cases. They don't know the law. They haven't been trained on it. They don't understand it. They don't know it. It was shocking and eye-opening. And at the time I was doing those cases, I had small children. And what this family went through to be accused of of abuse of your children when this daycare provider had done this is horrible.
A lot of times people see attorneys fighting for other people's rights and it seems badass and cool. This is heavy work, especially children. Children literally cannot stand up for themselves. Even if they could, they don't have, formed enough brains to understand their rights. That must be very heavy for you. And kind of, how do you separate that from life?
If you follow my Instagram, you may have seen one of my posts recently where it was a post that said, I'm polite until provoked. And it had this like little weird bear with like a knife. And I feel like that's kind of my like professional persona. I am polite until I'm provoked. But it is hard to separate it. But I don't know. I don't have a great thing to tell you other than I think all of us who do this work, we're really good at compartmentalizing our emotions. Yep. And that's just... I think you're conditioned over time as a lawyer. Maybe it starts in law school, right? I was just a mess the entire time in law school. But I mean, I don't know. At some point, I think the same for doctors or, any kind of a profession where they're
hospice nurses who spend like all this time with.
Yes. You have to compartmentalize because it is too heavy.
You get conditioned.
It is.
So let me tell you something funny. Yeah. Like when I was on the defense side, I could not compartmentalize. And in fact, the reason why I left PI defense work and went into employment defense work was because of working on cases against kids. It was very hard for me. I had 2 specific cases that I remember just like I couldn't do it. And I went and I was like, I'm going to do employment law. Like, screw this. One was a little girl who like stuck her finger into a hand dryer and got her finger sliced off. Mm-hmm. And my job in deposing her was basically to establish that she understood it was wrong and did it anyway, which was awful. Yeah. It was awful trying to like make that argument, but that was my job. I had to do it. I could not compartmentalize. I couldn't sleep at night. I mean, another case was a little 3-year-old boy who hopped onto an air conditioning unit on the 14th floor of his building and fell out of the unit. And the only reason he survived was because a tree broke his fall. And I had to depose his mom. At the time, I had a 3-year-old. I had to depose his mom and show that, like, they should have known not to let the 3-year-old climb on the
supervision.
Oh my
Those are the
God.
worst. I mean, that's
awful.
really hard. I don't know that if I were doing defense against these cases, I would be able to compartmentalize. I think that's really tough. I think, though, on plaintiff's side, we have the best job ever because we get to fight for them, right? Like, I'm going to freaking go down on any of my cases where I'm just fighting for you. I mean, that's like, how cool is that? And you just go all out.
There's a lot of purpose in that, I'm sure.
Yes.
It's satisfying to get the results for sure.
Yes. Yeah, absolutely.
And although sometimes it's only money and you can't fix the physical injuries that they have sustained or emotional pain, money helps.
It does. And how stoked are these kids when they're like, 2.5 when this thing happens. And then when they turn like 18, they get all this money and they're like, wow, where did this come from? So.
And now it's time for Let's Get Gritty, our audience Q&A. Here's the listener question. My sister's child was injured in a daycare accident, but she's afraid to sue. She thinks it'll make her look greedy. So what would you say to her?
This is something that people worry about a lot when they call me. And this is a question. They don't want to seem greedy. They don't want to, take the defendant's money. They don't understand how insurance works and all of that kind of stuff. And especially when it involves children, what I say is your child injured? Is your child suffering? I mean, what's your child going through? And I walk them through all of that and I say, that has a value. Do you agree?
The greed factor matters when there's insurance or there's no insurance, right? If it's if it's just a person you're suing and you like the person who owns the business or someone you work with where the child was injured or someone else was injured, and you know that the insurance is not going to cover it, then that person will sustain financial stress and damage as a result of what you may be recovering, even if the case is a lot, that could turn their life and their family upside down. But if there is insurance, then the business owner or whoever has already paid the insurance company and they're supposed to cover them if they do. And then I think that's okay and you shouldn't feel guilty if there is insurance coverage.
And that's a great explanation for sure. And I think they do have to understand, right, the difference. But I mean, I have a minors compromise in Marietta tomorrow. If you guys want to come, road trip, that involves a child who is bitten by a dog and the defendant is paying out of pocket a lot. Her case is worth a lot more, but there's no insurance. The insurance, there was an exclusion on the policy. This woman is paying out of pocket. And I understand that that's a financial burden. But I mean, this child is going to have lifelong issues and she should still be compensated.
I mean, and the thing is, in jury trials, the jurors get an instruction they cannot consider insurance. So in real life, when you're trying to settle and whether or not a lawsuit is filed, that's relevant, I think, to a person when they're deciding on personal level if they're going to want to go through with it. But when you're already in the middle of the trial, that's excluded information.
They don't get to hear it. Yeah.
Here's what I would add to the daycare situation. These laws are put in place not only to compensate for injuries, but also to prevent this from happening again. If you don't bring a lawsuit, if you don't hold the daycare accountable, it probably will happen again.
To other kids, which is sad. Like, things like that should not happen. And people who cause injury shouldn't continue to work.
That's a great point. People think we're just ambulance chasers. We're just out to get as much money as we can and then blast it all over Instagram and social media, right? But yes, there are some attorneys who are like that. But at the end of the day, our job is to hold people accountable, just like you're saying. That's what our job is, and to make things safer. So that's where I find solace.
About ambulance chasing, we restarted our personal injury department in 2025, and I get a call from someone in a Russian community, and they referred a personal injury client to me. Like, she's at the hospital, she wants to meet you. So I'm like, all right, I'll go to the hospital and meet her. So I came to the hospital, and in her room, this lady just got injured and had a serious car accident a day before. She had 12 lawyers already come to her at the hospital. They were not referred to. I don't know how they found out about her accident. Awesome. Probably they have connections through the police or ambulance people. I don't know how, but she didn't know those people. But they showed up, some at her hospital room, and I saw a bunch of retainers left. She didn't sign any of them. Ultimately, she signed up with our firm. We're helping her currently with her brain injury case and a serious car accident case. But I was surprised that, to me, that was ambulance chasing. Like, if somebody doesn't call you and ask you to come, then it's almost like inappropriate to just show up. This person is injured and you're just showing up there.
I'm pretty sure that's illegal. Or at least
so many people did
severe violation of our, code of ethics. Unfortunately, that happens. There's always going to be bad apples in every single profession.
Are you ready for this next segment? It's called red flag, green flag.
Yeah,
so you have
I'm just going to hold up the red one.
Probably smart. They're glamorous flags. And today's theme is, does this policy protect the people or the insurance companies?
A school installs a new playground equipment after a head injury by a child, but never notifies the parents.
Red flag.
Why?
A head injury is very serious and have long-term effects for the child. So parents have to be notified about that immediately.
Other parents, aside from the injured child's parents?
Other parents too, because they have a right to know at daycare centers what types of injuries and how many injuries have happened.
A term just came into my head from law school.
What?
Subsequent remedial measures.
Yes. Love it. Yes. I just signed a new case where that's an issue.
So talk about subsequent remedial measures. What does it mean?
Yeah. So it's favored, right? It's favored in society for if a person is injured somewhere and then a store or whatever fixes that problem, that's favored because you don't want somebody else to get hurt.
Right.
But as lawyers, we can't talk about it in court or in trial. You can't say, look, it was so negligent because, look, they fixed it later. You can't talk about it like
There's a jury instruction called subsequent remedial measures that doesn't permit you to talk about it.
That's right.
Basically, if a company, after an injury happens, fixes the injury after the fact, you can't bring it up in court or in trial to show that they must have been guilty because they fixed it later.
That's right. You said it much better than I did. Yeah. Lots of ways around it. So
tell us the secrets to get around it.
Yeah, so if you're just using it to show control, right? It's not to show negligence. It's to show that defendant painted that curb stop. So they're in charge of that curb stop. That's all we're trying to show. We're not trying to show.
So all you need is like a little piece in their deposition where they're like, we had no control over this place. And then 100%. You're like, oh, huh. Yeah. But you painted it later.
Yeah. Go to the jury instruction, go to the annotations, find out what all the exceptions are and ask all of those questions in your deposition to try to poke it. But yeah, there's a ton of ways around it.
God, being a lawyer is so fun.
It's so fun. Strategically, it's amazing.
And the reason that exists, the subsequent remedial measures, jury instructions, is to incentivize companies to fix things so injuries don't keep happening again and again.
Policy. I think that's the reason we have it, is because if we didn't have that jury instruction, then people wouldn't fix things until lawsuits are over, and then there would be more injuries and more payouts by insurance companies and more people hurt.
What's crazy is if they can fix it and it is so cheap to fix it and then they choose not to because they're worried about it looking bad. That's crazy.
Yeah.
They should fix it. Yeah.
All right, let's do the next one.
Okay.
What's the next question?
An insurance company agrees to a payout but then delays disbursement for 14 months.
Red flag. Very bad. Yeah. What I've been doing in my releases is I have a time frame. Part of what we agree to is a time frame for when the check has to come in. It's a little tricky sometimes if you're dealing with getting liens and stuff resolved, especially governmental liens, right? They can take a long time. But I still put the provision in there.
How much time do you give them?
Usually it's 30 days that I will be paid once they receive the executed release within 30 days. Because it's not fair. I mean, your clients, they don't understand all this. And so
30 days is generous.
that is very generous. Yeah. So that's what I do.
Yeah.
Okay. Red or green flag. A hospital voluntarily discloses a medical error to the family and offers to cover long-term care before a lawsuit is filed.
That is both, because maybe they're agreeing to pay for the long-term care, but they're not giving you an opportunity to negotiate what the fair amount would be for that, right? So that person might think, oh, well, they're paying, they're taking responsibility, they're doing everything right, but maybe they're paying 50% or less of what they really should be paying. So that's both.
Yeah. And I think
it's good to speak with a lawyer, because a lawyer may be able to cover other damages aside from, long-term care. Special damage is financial, but there's also emotional damage. There's pain and suffering, which is worth money that a lawyer can negotiate.
I mean, this happens all the time with clients who maybe they have a case with their own insurance company, and the insurance company is like, don't worry, we'll take care of you like a good neighbor, and we'll give you $1,000 on your brain injury. And the people think like, oh, they're giving me money. I mean, why do I need a lawyer?
Yeah.
Well, because your case is probably worth $1 million. So
Yeah.
yeah.
So the answer is don't trust the insurance
Don't
company.
trust anyone.
Well, and when you have an injury, you don't necessarily know what your long-term care may be.
No. And they try to do a settlement really quick
Yeah.
before you know kind of what's going on with you. So, yeah.
Agreed.
Mm-hmm.
Okay. A medical group issues a public statement of accountability but denies all liability in court.
Yeah, bad. Very bad.
Yeah.
Yeah. I mean, that just adds insult to injury for the family and the victims that have suffered an injury at the hands of the defendant. And then to get to court and completely change their tune and fight you and ridicule you.
A defense attorney tells the jury, kids are resilient. They'll bounce back.
Yeah, no, red flag.
Oh, yeah.
Yeah, for sure. 100%.
Kids are so not resilient.
Let them say that. They're just digging their own grave
That's
and
true.
saying that, because you will get up there and through your experts and the testimony from the parents and teachers that, this child wasn't able to be resilient in this type of a situation and with this type of an injury. So while that's a cute little phrase to use, that doesn't apply to the case.
Oh, I would not want to go against you in trial.
Yeah, I can see the fire.
I love it. I love
Polite
it.
until provoked.
Okay.
Red or green flag. The hospital apologizes for a surgical error but forces the family to sign a non-disclosure agreement.
Red flag. All day.
They can't really force anybody to sign it without paying them.
Well, they can ask them to sign it.
And people might not know, right?
I mean, when you get presented a whole bunch of documents that are legalese and boilerplate, most people, especially at the time of stress, that's not what their mind is. They may
100%.
just sign it without reading it. I mean, I'm a lawyer, and I sometimes don't want to read it. I'm like, psh, 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 done. Here's the paperwork.
100%. Not okay.
Especially when you're vulnerable
Sneaky.
and you're dealing with an injured child. I mean, you're not going to really be able to use your brain to the full capacity.
Yeah, no. Super sneaky, underhanded, red flag.
Yeah.
On these cases, you have to do minors compromise, and the funds are held in an interest-bearing account until the child turns 18, but you can petition the court to get the money sooner.
In every single minor's case, the money either has to go into a blocked account, and typically for kind of lower settlements. So if a child's net is anywhere from maybe $5,000 to $20,000, that money would generally go into a blocked account, and you petition the court if you need to get it out sooner and whatever. If the money that they're getting in their net is more than $20,000, then you would put it into an annuity, which is a much better option, because you get a nice interest rate that they're earning. The younger they are, the more that it compounds until the time that it starts to pay out. It's nice in an annuity situation because the parents can decide when the payments happen, and you could have those, stretched out where you're only getting a certain lump sum payment every year for 10 years or whatever. But in every case, there has to be a judge kind of overseeing to make sure that the settlement is fair. And most of the time it's fine. I did have a situation last year where the judge did have some questions because it was involved a child and a mom. And So, the judge really wanted to make sure that the settlement to the child was fair in that situation. So that one, there was definitely some back and forth in terms of explaining the breakdown of the settlement and how it was fair to both of them.
Yeah, I mean, the purpose of minors' compromise is to preserve the money for the children, for them to have it when they're of age versus parents spending it now on other things.
So sometimes, the judge will say, okay, this $1,000 or whatever can go to the parents directly now. And if they need more later, they can petition later. But that just, I don't know, that is not happened for me in my cases. But more often than not, we will be able to carve out an amount for the parents out of the children's settlement. But the courts are very particular in terms of what they will give for that, right? So it has to be for school clothes. Sometimes they'll do it. Laptops, I've seen them do it. But one time I had a case involving a child, and he's a spastic quadriplegic who was injured in a school incident. But he needed transportation, and the mom needed a van. And so out of the settlement, she asked the court if she could have a van for transporting the child, and the court said no. I mean, that's something that as a parent, you would just need to provide for this child. The injury of a spastic quadriplegic did not happen from this case. That was a condition that the child had from very little. So
okay,
the court said no.
So what you're saying is that if it was specific to the injury for which the child is being compensated, then the court would be more flexible and accommodating a request like buying a van versus being a pre-existing condition.
I think I could have made a stronger argument for sure if it had arisen out of the actual injury. The best thing about representing children too is they haven't done anything wrong, right?
Yeah.
Like they're completely innocent. These things have happened to them. So I think any defense attorney would be crazy to really want to take that to trial and to try to fight it in that way in front of a jury. In a case that I had involving that child who was spastic quadriplegic, he had a broken femur at a daycare center during a diaper change. But why?
How old was he?
10. But how do you think a jury is going to be so sympathetic to that poor child? He did absolutely nothing wrong. This was done to him. But once you met this child and his mom, and she was a single mom, and she was trying to take care of her child, and he had to be lifted. He had absolutely no mobility, could not eat on his own, couldn't do anything on his own. So it's just yes, I'm going to help you. I don't care what the outcome is.
Wait, did he become
No, that happened earlier in his childhood. And then
What happened?
So he was at a daycare center, and he had to be lifted up. The teacher took him into a back area to change his diaper. And while he was back there with the teacher, the aide who was in the front of the daycare center heard this child scream, which is not a normal thing for this child. He has sounds, he can do sounds, but that's not a normal one. You know your kids, there's 12 different cries and you know what they all mean, right?
I know exactly what you mean.
So when you hear that one, that's oh no, something's wrong here. They don't have to say anything. And that's what she heard. And so she went back there, and this child was completely pale white. He was sweating. He was super uncomfortable. He was moaning. And
how did his femur get broken? Somebody punch him, throw him down?
So what? Our burden of proof is 51%, right? More likely than not. And that's what a jury decides on. And so our expert, who was a pediatric orthopedic surgeon, he testified that most likely what happened, and based on the teacher's testimony, is that she only pulled his pants to mid-thigh, right? On a normal able-bodied child who doesn't have an atrophied body and weak bones, that's okay, right? I changed my kids' diapers like that a million times. You put it at mid-thigh, you lift up their legs, you clean it, right? It's fine. Not on children like this. You have to take their pants all the way down. So when she only took it to mid-thigh, when she tried to open up his legs, the pants acted as a fulcrum and just snapped.
Oh my.
Snapped his leg.
Oh.
And so and then I think she saw it happen and quickly tried to like fix it and put everything up. But all the standard of care experts, everybody was like, you cannot change a diaper like that in this type of a child. Even the other aides who had changed his diaper, they're
Did
like,
she admit to doing that?
No, she never admitted.
Huh.
Never admitted. It had to take a jury 2 times because the first time in that case there was a hung jury.
Oh wow.
So
you
and-
did it twice.
Yes.
Oh,
So 2
You're a
times
hero.
a jury
literally doing
did.
God's work.
Oh my God, you have no idea. That case was so stressful because you want to just like get justice, right?
Yeah.
You want them to see it your way, and
That's
you
a real
hope
war
that
story.
you're communicating it to them to see it. But we knew that, you know, it was going to go okay when all the jurors started crying and passing the tissue box, like, you know, across the way. And then you know that, okay, we're getting somewhere.
What
They're
did the jury find
understanding.
for that
So
case?
screwed up that
They're
she just wouldn't take
understanding.
responsibility and putting that family on top of it through trial
Oh,
and
they said
another
that mom did
trial.
it. That was their theory. Mom probably happened when mom was putting him in the car. His bones are so
How
weak.
unfair. Like, just take
Super unfair.
responsibility. You
Yeah.
did it. Like, make people's life easier.
Super unfair.
Adding
What did
trauma
the
to
jury
trauma.
find for that case?
I believe that their verdict was 163,000, which, you know, honestly, in the first trial, we asked for a lot more. When we polled the juries afterwards, they weren't, because this child had such severe injuries,
Yeah.
like, you know, from
He didn't
his
think quality of
condition.
life would change as much.
Exactly. So even though, you know, we really worked a lot on showing how his quality of life did suffer, and it really did. I mean, he has such a limited way to find joy, and then he was confined to like a spica cast. But right, like it just, his medical bills were super low, negligible. And
I'm sure he already had so many medical bills that this was just like a drop in a bucket of water.
This was truly about justice. Like,
Yeah,
you can't freaking break this kid's leg at school and then lie about it. And because he can't speak, just
Absolutely.
act like you didn't do it.
Yeah.
That's not okay for our society
Absolutely.
to have people
Thank you
who
for
would be
doing this and
willing to
helping
do
them.
that. Yeah.
It's nice to know that somebody's taken those cases because
Yeah.
it's true. Not everyone would want to take this case.
Yeah. Injuries at school, I mean, you know, they happen more than you think.
Glam tip of the week. Today's glam tip: find a small thing to help you feel grounded and glamorous.
Maybe it's a special face mask with a glass of wine on a Friday night. Find your thing that gives you a bubble of you time in a sea of career and family obligations. This is The Glamorous Grind, and today's takeaway: empathy makes you strong.
To our listeners, if your child, your family, and your peace is disturbed, don't shrink back. Fight smart and find someone like Keri to help you.
See you next week.